from College of Law, where I am the Maxine Kurtz Faculty Research Scholar and Professor of Law. Thanks so much for joining us today for this exciting program, which is jointly sponsored by the AALS sections on state and local government, of which I'm the chair, and natural resources and energy law, of which Keith Rizzardi is the chair. It's co-sponsored by the sections on environmental law and agricultural and food law. Our program today will be divided into two parts. Part one, which I will be moderating, will address the current role of state and local government laws in environmental sustainability. Under the Trump administration, the federal government dramatically reduced its leadership in tackling issues of sustainability and environmentalism. At the same time, many state and local governments have long been leaders in the area of sustainability. Some of our colleagues have even created model state and local sustainability ordinances. Our program today looks at some of these state and local efforts surrounding environmental sustainability. Our speakers on the first panel will discuss a variety of state and local statutes, ordinances, and programs related to these issues, including discussions of aquaculture, trafficking of endangered species, groundwater management, and high-end condominiums. Our final panelists will discuss limits on state environmental action, which will then segue into the second part of our program. Part two, which will begin at 4 p.m. Eastern Time, will be moderated by Keith Rizzardi and will address emerging obstacles to state and local attempts at environmental sustainability. This part will focus on some of the challenges facing state and local actors wanting to take action in this arena. For our first panel, we have 5 great speakers at all different stages of their careers. Each will have approximately 15 minutes to discuss their papers and take questions from the audience. Thus, I encourage you to put questions in the chat, which I will be monitoring during each panelist's talk. In the interest of time, I will let each panelist more thoroughly introduce themselves. But first up, we have Professor Robin Craig from the University of Utah.
All right. Thank you, everyone. And good afternoon. It's a pleasure to be here. My topic, my paper is on sustainable aquaculture and the role of state governments in pursuing that. It is a little bit of a wacky world right now, but that's kind of the point of investigating it now, particularly because ocean sustainability and the role of marine food in food security and sustainability is not well explored in the literature. So just to provide some background, if you are worried about food security, fish and seafood is an important component of protein for a lot of the world. This graphic comes from the UN Food and Agriculture Organization. The darker the blue, the more the country depends on fish and seafood for its protein. And what's interesting about this is the dark blue countries are both developing nations and highly developed nations like Japan and Norway. The United States comes in the middle, but again, fish and seafood are an important component of our protein sources and thus of our food security. Why that's important is because wild capture fisheries have been leveled off for several decades now. They leveled off in the 1990s, and aquaculture production has been filling the increased demand. The leveling off of wild capture fisheries is despite increased efforts to catch marine fish and despite improved technologies for doing so. And even organizations like the World Bank acknowledge that wild-caught marine fisheries no longer respond to price signals. No matter how much you are willing to pay for a large bluefin tuna, it's not going to produce any more results in catching one. So as you can see from this graph, the blue aquaculture production, which on this graph does include freshwater, has been accelerating considerably since about the 1980s, and in 2012 reached the milestone of actually producing more fish and seafood protein than capture fisheries do worldwide. That is particularly true in China. China leads the world in aquaculture production at the moment, but other areas of the globe are trying to catch up. But not so much the United States. United States aquaculture production has remained relatively stable for the last 5 or 6 decades and is not doing as much as it could yet to fulfill our food security and sustainable seafood needs. And that's interesting in part because the United States as a country it consumes less freshwater fish proportionally than it does marine species. So the fact that we're not engaged in more marine aquaculture will probably change considerably. And as you can see, we're kind of spread out on what we eat from the ocean. The purple is the one you might not recognize. That's ground fish like halibut. All right, so the United States right now imports about 90% of the seafood that Americans eat. Half of that is produced by aquaculture in other countries, and we do have a trade deficit in our seafood. Our advantage in terms of sustainable aquaculture is that unlike most countries that engage in marine aquaculture, a lot of our aquaculture already involves bivalve mollusks, i.e. oysters, clams, and mussels, which are filter feeders. They improve water quality, and they are a very sustainable way forward in aquaculture. So that's the background. What does all this have to do with states? Well, in this very complicated diagram about marine jurisdiction in the United States, the important part is that even though the oceans are basically federal, thanks to the 1953 Federal Submerged Lands Act, coastal states control the first 3 miles of the ocean. And at least for the moment, that is where most marine aquaculture occurs. The federal government has recently made a push to start having aquaculture in federal waters. That may become an issue probably in the next decade. But for right now, we're talking about state management. So if we want sustainable marine aquaculture, it's going to be the states that are doing it. And NOAA has a very rosy vision of what this will look like, emphasizing again oyster, mussel, clams, and algae as the sustainable aquaculture goals, but also noting that some net pen aquaculture, which if I just said that, you're probably thinking salmon, but there are actually a lot of operations now that involve far less environmentally destructive species than salmon, such as native species of Hawaiian fish that eat plankton. So what are we looking for sustainable marine aquaculture? What we need are species that are low on the food chain, algae or seaweed, for which there is a bigger market than you might think. Filter feeders like clams and oysters, again, you get water quality benefits with them as well, and plankton-eating fish. We also want to be growing native species for each area because they will escape. That happens. And if they are native species, the environmental impacts are greatly reduced. We also want to be growing species that can be reproduced in labs or in situ, so that we're not harvesting wild species to provide the stock. And for overall market sustainability, focusing on local and regional markets to keep transportation costs, both economic and environmental, down. Then finally, siting aquaculture. As you can see from this photo, aquaculture does take some space. Should be sited according to comprehensive marine spatial planning to minimize conflicts both among humans. So you don't want to be putting aquaculture operations in shipping lanes as one obvious example, but also to minimize conflicts with marine ecosystems. All of which adds up to, if states are going to be increasing marine aquaculture, and everything points to the fact that they will be, you want a state agency with marine expertise in charge of what's happening. That, however, is not the current state. So this paper is doing a 38-state plus territory survey of how aquaculture is currently regulated in the United States. We have 38 coastal states. That includes the Great Lakes states and several marine territories. And of all of those, so far, only 6 states and 1 territory actually regulate marine aquacultures through their primary marine agencies. There are many states that lodge that in their environmental, natural resource, or conservation agencies, usually natural resource or fish and wildlife agencies. But there's also a large collection of states that view marine aquaculture as a form of agriculture, which is not likely to lead to sustainable aquaculture on a larger scale. So, a couple last points before I run out of time. The other thing to look at with state aquaculture regulation is it involves a variety of state and federal authorities. Even if you have a main permitting agency, you usually have 3 to 7 state agencies that have something to say about how marine aquaculture is conducted, including at the end of the line, the State Department of Health. And also the Army Corps of Engineers with a Rivers and Harbors Act Section 10 permit, because these are constructions in the ocean. So my concluding thought for now is that a bigger picture approach is going to be necessary, especially as the federal government begins to actively promote aquacultures in federal waters beyond 3 miles, and particularly as the oceans become more crowded. The picture here shows one concept of how to co-locate activities such as offshore wind farms, which are starting to come online in the United States as well, with aquaculture and some other activities, all of which requires more coordination than states are providing right now. Thank you.
Thank you so much, Robin. That was great. So we do have one question from the audience. And again, please feel free to place your questions in the chat box. So Steve Gold asked whether you're looking at all at state agency institutional competence or capture, even of the state marine regulators.
I am. This is, as you might imagine, a long, complex project looking at about 51 different governments when all is said and done. But yeah, and that's why I flagged which states, even if they lodge their marine aquaculture in a non-marine agency, do lodge it with their state Coastal Zone Management Act agency. But yes, the issues of capture, and that varies a lot from state to state, as you might expect. Some states like Washington have a very strong program of aquaculture regulation, cooperating with industry, but without the signs of industry capture. Other states, and I will say, let's say several Gulf of Mexico states, have less robust programs that are more subject to industry influence.
Great. Robert Fishman asks or comments, nearshore co-location with wind farms seems like a good fit. How difficult would that be to pull off jurisdictionally?
Right now, very difficult, given that wind farms also have some jurisdictional battles still being fought. But technologically, Europe's been experimenting with it, and if the political will is there are ways to thread the regulatory jurisdictional issues.
Great. All right. We've got a couple of questions. I think maybe I'll put a few together. So Lori asked whether any states have considered some sort of shared regulatory structure where the agencies of agriculture are involved with the marine agencies. She said she could see some of the benefits to including the agricultural agencies. Another user, sorry, the names have gone away from me, is curious about your views on the utility of the EPA here, or specifically EPA's regulations of aquaculture farms.
Okay, so lots of questions there. Yes, there are states that already, I would say, divide more than share regulatory authority over aquaculture, but there's no reason that those state agencies couldn't work together more completely. And as for the EPA, the EPA primarily regulates aquaculture as a water quality issue, so it has authority over confined aquaculture facilities, the marine equivalent of CAFOs, basically. But that's with a water quality eye. The EPA does not have the authority to do the siting or the leasing of the submerged lands that are owned by the state. And so it is, as with everything in this field, it is an incomplete regulator at best.
Great. And I think we've maybe got time for you to give a one minute response. I'll read you the last two questions we have. Is state regulation likely to promote aquaculture or to smother it with overregulation? And what about saltwater versus freshwater? Heidi asks. We're having trouble even getting a wind energy farm permitted in Lake Erie.
Okay.
1 minute response.
Okay, so Great Lakes are pretty much oceans for most of federal regulations, so it shouldn't be considerably different in the Great Lakes, aside from the species you would be growing, obviously. And as for, and I'm even forgetting the first question.
Well, we're out of time anyway. The first was about overregulation. But thank you so much, Robin. That was great. And again, if we have time at the end, maybe we can come back for more questions. So our next speaker, thank you. Our next speaker is Priya Sundaresan from the University of Arizona. Priya.
Hi. Thank you, Sarah. So I'm Priya Sundaresan. I am in my second year directing the Natural Resource Use and Management Clinic at the University of Arizona's James E. Rogers College of Law. I would classify myself as a junior scholar here. So, and I really do welcome input, suggestions from my esteemed colleagues watching who have, potentially relevant experience and expertise in some of this this area that I will be presenting on. My topic is the application of financial sanctions against criminal networks to address wildlife trafficking, and of course to apply it in the state and local context, which is the subject of this panel. This work follows from my paper that was published in April of this year in the Arizona Journal of Environmental Law and Policy. And also I'll briefly summarize that work and how it translates into the state and local context. So I come to this area having learned of the extremely endangered vaquita porpoise, which is endemic to the Gulf of California. I came across it in the context of my work previously. A few years ago, I was on the oceans team at the Environmental Defense Fund, where some of my colleagues were working on this issue, but not me. But as I learned about it, it really intrigued me. And so that's part of the reason why I have delved a little further into this topic. But I think that the lessons here can apply to species, endangered species and trafficked species more broadly, not just the vaquita. But starting with the vaquita as an example, it's an incredibly dire situation. From the headlines, you can see that over the last few years, it has really, plummeted in population. But nevertheless, there's a headline from October of this year that suggests that they may still remain genetically healthy, which provides hope that they might recover given some proper management. And of course, the story of this porpoise is that they're being caught in the Gulf of California in nets that are actually set to capture a different endangered species of fish, the totoaba, which has also been referred to as aquatic cocaine for its value in the Chinese market, especially for its swim bladder. And so the totoaba swim bladder gets trafficked from Mexico, and sometimes through the United States and then to China, or directly from Mexico to China. And there's been a lot of good investigative work done by various nonprofit organizations to look into these trafficking routes and document the seizures of totoaba when they do occur. But unfortunately, in this area, a lot of the trafficking occurs along with drug trafficking, and in fact has been taken over by the drug cartels, which really adds complexity to this situation. Enforcement methods to date have focused on the activity in Mexico and really focused on the poaching and the activity of Mexican fishermen. So I list here a few of the actions that have occurred over time. There's been a refuge created in the region in 2005. in Mexico. They've tried to buy out the fishermen by purchasing their buybacks of the permits, conducting net turn-ins, and then more recently they've implemented bans on the gill nets, which are the type of fishing nets used to catch the species that actually end up harming the vaquita. And the gill net ban was made permanent in 2017. And the U.S. has also gotten in on the action. In 2018, there was an import ban implemented on products from the upper Gulf, and most recently, the National Marine Fisheries Service, or NOAA Fisheries, revoked the Marine Mammal Protection Act's comparability findings for Mexico from products from that region, which means that most fish products from that region cannot be imported in the United States. And a lot of the advocacy conducted by nonprofit organizations has asked for more Mexican enforcement of these fishing bans, as well as similar types of U.S. action in terms of trade sanctions and bans. And so this has been the avenue so far for how to attempt to prevent the totoaba poaching and vaquita incidental deaths. But unfortunately, it continues, and you can ask other advocacy organizations. They've continued to see poaching activities occur. And part of that is the focus on poaching activities and the focus on the fishermen activities in Mexico puts the Mexican fishermen in a really tough bind. A lot of them are fishermen by trade, and removing their abilities for economic activity only forces them into the illegal fishing activity. So it's not, it doesn't seem to be a solution that has worked. It also hasn't prevented these larger trafficking networks from continuing to operate, from forcing those fishermen to stop their lawful fishing activity and join the illicit fishing activity. So instead, I think it's more important to follow and stop the flow of money. And I bring up the recent, well, I suppose not so recent now, but at least a year and a half ago, the Sea of Shadows documentary did follow that kind of mentality, where they tracked the major cartel players. They discussed the lack of prosecution and enforcement in Mexico and the corruption of local Mexican authorities. But they also recommended going after the trafficking further down in the supply chain. So they recommended that the Chinese government as well focus on the traffickers who, and this is critical, they also participate in additional crimes such as bribing customs officials, money laundering, and human trafficking. So eventually we'll get to the state and local aspects of this. There have been some advocacy, oriented on focusing on these traffickers, but so far it has been to decry the lack of enforcement. There's been a letter sent by a few nonprofits requesting additional enforcement of these of the people who have been found to be trafficking these products, and stating, just in the list of folks that have been stopped, very few have been actually prosecuted. And so actions that I would recommend are to actually charge, confiscate the assets, seek sanctions for these traffickers, so totoaba, but other wildlife. I think this applies broadly, caught at border stops. Investigations, I think, should go beyond the Lacey Act, to include the many financial crimes that are committed in trafficking operations, because when they are conducting these illegal, when they're moving illegal wildlife products, there's necessarily going to be smuggling, money laundering, bribery committed alongside these efforts. And then to explore the use of financial sanctions. And I list a few statutes that exist that could potentially make a difference, perhaps the Magnitsky Act or the Drug Kingpin Act, that could be used to effectively target these traffickers. I bring up an example of The Codfather, which was a very splashy story in recent years of a longtime fishing violator who finally his operations were stopped when he was charged with various non-wildlife related charges. These falsifying false records, cash smuggling, conspiracy, tax evasion, which ended up providing the bulk of the actual fines against him. So again, the federal tools that could potentially provide avenues to go after the money, which I think are the more important and more effective way to stop the flow and stop these activities. Anyway, so the question here is, are there parallel efforts available at the state and local level? And I think that the answer is yes. Why not? There are various states have wildlife trafficking laws. There are also animal abuse laws and other animal law efforts conducted at the state level. But moving to more of the point of my previous paper is I think that we really could be more effective by considering the financial crimes and financial sanctions involved with the kind of this illegal activity that are associated with this kind of illegal activity. So the money laundering, the racketeering, the tax evasion and tax status, and conspiracy, to name just a few. And so if there are comparable state laws, those could also be used to stop this activity more effectively. That said, there are a number of state wildlife trafficking laws, and so I listed a few that, with the help of one of our law library fellows, we came up with a few examples. So many states do include wildlife trafficking laws, which come with criminal penalties, monetary penalties, and I think the monetary penalties, again, are the ones that I would really focus on because the activities here, especially when you're talking about networks, require money in order to operate. Some of these statutes are specific to listed species, and then some of these are a little more broad. I think the South Carolina statute here is broader, but I would my area for future focus is to really take a look at these statutes and determine the effectiveness of each of them. Similarly, I've been looking into animal law. A lot of the animal law victories can depend on the associated crimes that are committed. For example, this year in Indiana, the Attorney General had brought a suit against against a private zoo owner who has been long known for animal abuse and other issues, but the Attorney General brought suit over their nonprofit tax status. So I think it provides an interesting parallel about that avenue for shutting down the kind of operations that we see based on these financial crimes. And as I learned a little bit more about animal law, there is a caution against using some of these laws and animal abuse laws in order to push a pro-carceral approach. Professor Justin Marceau of University of Denver actually visited U of A earlier this year and provided a good example of the need to be aware of some of the impacts that fall disproportionately on poor people and people of color. And importantly, not actually improving animal welfare and diverting attention from the systemic reform that would actually be needed to make an impact. So just wanted to point that out as an important point, but also I think matches with what I would advocate, which is to focus on the financial sanctions rather than on jail time. And then, of course, there are other state law violations that could be used. Many states have money laundering statutes with both criminal penalties and civil. And again, those include financial penalties, which I would advocate use of. Similarly, racketeering and organized crime, tax evasion, etc. I am not at all an expert on criminal law, so I would love to hear from those who are, and I'll leave it there. And if there are any questions, happy to answer them. Or if there's anyone who's interested in working with me to co-author on this, providing additional expertise in that area, I welcome that too.
Great. Thank you so much, Priya. So I think to stay on schedule, we're not going to have time for out loud questions right now, but if anyone has questions for Priya, please place them in the chat and she can respond to them that way. So next up, we have Jennifer Harder from the University of the Pacific, McGeorge School of Law. Jennifer?
Thank you so much. I hope everybody can hear me. I'm glad to be here today. I was really excited to see that the theme of the conference was the power of words, because it provides me an opportunity to talk about some of the work that I've been doing related to California's experience thus far with integrating marginalized communities into state and local environmental processes through the example of California's Sustainable Groundwater Management Act, or you might hear me call it SGMA, which was enacted in 2014 and recently passed some major milestones in its compliance timeline. So this discussion focuses on the participation of the disadvantaged communities and the giving them a voice in this environmental process. And so we're not focused on the outcomes at this point. The assumption of this presentation is twofold. One is that increased participation in state and local agency processes is desirable. And second, that enhanced participation by disadvantaged communities, sometimes referred to as DACs, because we need more acronyms, as a discrete group is also desirable. And of course, as to the first proposition, there are a variety of viewpoints, both skeptics and proponents. I will say that with respect to disadvantaged communities in particular, the salient value to highlight here is the value of procedural justice, which ultimately supports values of dignity, equality, and autonomy, which have largely been denied to these communities, which are still suffering from past exclusion and systemic deprivation of basic support for health, education, and other opportunities. And I think that recent events in the world demonstrate that incorporation of these missing voices into governance and policy is critical. So a little background on groundwater in California. It's very important, making up almost 40% of our supply and more in dry years and in some regions. But California largely had a legacy of unregulated, unmanaged groundwater, with some exceptions in some regions for court decrees and special districts. But in the biggest ag areas of the state in the San Joaquin Valley, where many of the disadvantaged communities are located, there wasn't statewide regulation. And that all came to a head with the significant drought that we've experienced in the past 15 years, when we saw many wells going dry in those areas, loss of storage, increased contamination, and land subsidence. And many of the communities that were going without water were these disadvantaged communities. So the philosophy of SGMA is continued local management of groundwater, as it has been for 100 plus years, with a state regulatory backstop where the state can step in if the locals fail to achieve certain goals. One of the exciting things about SGMA is that it requires the creation of new local agencies called groundwater sustainability agencies. You may hear me call these GSAs. A GSA can be an existing agency, a special district, or an agency with the land use power, or you can have multiple agencies that enter into a joint powers agreement or enter into an MOU. And you can have one GSA in a basin or multiple GSAs in a basin. And so this is a really exciting time for those of us who are interested in institutions and governance as we track the evolution of these strange new creatures. So what are the responsibilities of these GSAs? Basically, they are to create these groundwater sustainability plans, sometimes called GSPs. The critically overdrafted basin plans were due January 31st, 2020. Everyone else's is due January 31st, 2022, and they're supposed to achieve sustainability within 20 years. And you can see where these high priority basins are in the map on the screen, with the oranger colors being the most impacted basins. So in these basins, you have approximately 250 communities that meet the definition of disadvantaged community. For purposes of SGMA, the Department of Water Resources defines disadvantaged communities as having a median household income of less than 80% of the statewide median household income. That's different than other regulatory contexts. In the San Joaquin Valley, many of these communities are demographically identified as rural and largely Latino. So one of the things that was different about SGMA and exciting was that the issue of the failing wells in these disadvantaged communities was prominent in the media during the drought, thanks largely to the effort of non-governmental advocacy organizations such as the Community Water Center and others. And in a new development, CWC, the Water Center, was at the table when the law was drafted. And as a result, SGMA contains this express requirement that the GSAs must consider the interests of all users and all uses, including those of disadvantaged communities. So when we talk about participation, there are a lot of different models for information exchange. I want to focus here on the fact that when we talk about participation, we're not talking about one-way communication. We're talking about information flowing in both directions, and that's the ideal. We can, for purposes of this presentation, I will break the participation rubric down into three categories. There are, of course, more. One is this field of dreams theory. If you build it, they will come. You offer a public process and you hope people will show up. More traditional process. There's a lot of literature around collaborative governance in which the public agency is engaged in a decision-making process that has some interaction. There are a lot of different definitions for collaborative governments. It's hard to pin it down, but the most specific comes from Ansel and Gash in 2008, which says essentially that the collaborative governance looks at consensus-oriented processes. So you're looking for consensus toward the end, and all the decision makers have a voice. Then there's this theory of meaningful engagement, which is the concept of the community provided with information that they need to understand and respond, to be heard, and to build their own capacity over time with attention to the impacts of past exclusion. So in the information I'm going to present now, this comes largely from, there's a bunch of great studies going on. The ones that I want to highlight come out of primarily University of California, Davis, Mark Lubell, and Kristen Dobbin, who is an excellent social scientist, political scientist in these areas. And so Kristen Dobbin has done a number of statistical studies to look at what's happening with participation in the GSPs that were issued in January of 2020. And the report card on these are mixed. They're finding that about 27% of these outline specific steps for stakeholders generally, but not for the disadvantaged communities. 39% of them only referenced engagement, but didn't give any details about it. And 34% of it did not discuss their engagement plans at all. So if you think about the fact that if you assume that discussion of engagement in these plans means that the engagement occurred, these are mixed results and somewhat disheartening. Dobbin also reports that out of the 41 GSPs, only 50%, but 50% recognized the disadvantaged communities as interested parties. Much fewer had the disadvantaged communities participating as decision makers. Dobbin also noted that from a representation standpoint, the GSPs had identified one or more representatives from the disadvantaged communities who served on boards, committees, or otherwise attended meetings regularly. Out of the ones she surveyed, there were 12. For 7 of the GSPs, the representatives attended meetings more sporadically, and no representative attended the GSA proceedings. But only 1 to 2 general events. There were 5 of those. So fairly low numbers. And when she ran these numbers, she discovered that in the representation, it wasn't necessarily the case that a disadvantaged community member sitting on the board or committee of the GSA actually resulted in more participation. That there was something else besides formal acknowledgement and a formal seat at the table that was driving participation. And so she undertook a series of structured interviews with these communities, and she discovered several things. One is that the primary drivers of lack of participation and under-participation is lack of access and lack of influence. So when we talk about lack of access, well, we're primarily talking about things like financial resources, lack of transportation, other competing commitments, language barriers, and inability to engage on the technical elements, which becomes important in a minute, to understand the hydrology, the accounting, and everything else that goes into preparing these sustainability plans. And it was reported that the communities stopped participating in part because they felt like they had nothing to offer. Another element of the lack of access was a lack of transparency. And here there was a general concern expressed about lack of legally required notice, canceled or rescheduled meetings, use of closed sessions, and a general sense that the real work was being done outside of the meetings, all of which is very troubling. So the other aspect of lack of representation is lack of influence. And when Dobbin undertook these interviews, she found that over and over again, she heard from these communities, particularly the people who had positions on the boards or on the committees, that they had voice but not vote. In fact, she heard this so many times that she ended up adding a new category to her survey to track these. The participants reported feeling uncomfortable and intimidated, and as if they were treated with condescension during the process. And all of this is troubling. It also gives us some place to focus as we move forward. One of the bright spots that I want to highlight is in this process is the participation of non-governmental organizations like the Community Water Center, the Leadership Council, and Self-Help Enterprises, which received grant funding from a 2018 General Obligation Bond, Prop 68, and they've used this money to create a multidisciplinary technical assistance program. What they did with this money was fascinating. They did some of the traditional outreach. They translated materials so that they were bilingual, provided some direct services in terms of preparing documents. But even more importantly, they used the grant funding to retain professional services. They retained consultants for these disadvantaged community groups. And the consultants would go in and they would talk to the communities about water budgets, about fees, about hydrology and water accounting, and all of the other technical information that they needed to participate in the process. And so from this sort of bright spot in what is otherwise a very mixed and somewhat negative result, is to look ahead and to think about how do we take what worked well and translate it into law and into policy and prescriptions going forward. And so I have a few recommendations that we're exploring. One is exploring the potential for new positive standards, statutory or regulatory, or incentives or coupled with incentives regarding the timing, nature, and frequency of outreach to these communities, requiring that the agencies, the GSAs, use the best available information regarding engagement. And there's a lot of great literature out there about that. And state mandated agency training. At present, California requires its local government leaders to undertake ethics training. This kind of training about working with disadvantaged communities could easily be added to those. Another important point is to foster the development of relationships ahead of time. It appears, based on everything we've seen, that 80% of the work takes place before the public meeting, and that includes working with the disadvantaged communities to prepare them. The disadvantaged communities that were most successful based on the research are those that had actually partnered with the local governments ahead of time on other matters. So they had existing relationships. So if you work on those relationships in small chunks leading up to a major issue, then you have the opportunity to do some better work going ahead. And I want to here focus finally on my two key things, which are to continue this mission of community capacity building and community empowerment through workshops and training, and through funding to facilitate those workshops and trainings, building community leaders. These organizations are training some of these folks in the communities to take leadership positions in their local governments themselves. And the other, and this is where I'm having continuing conversations with folks, is around increased institutionalization of disadvantaged community issues on water, institutionalizing water justice, looking at the model of a proxy advocate, sometimes called a regulatory contrarian, such as that exists within the California Public Utilities Commission, Office of the Public Advocate, used to be called the Ratepayer Advocate, or similar models where someone at both the state and local levels has the responsibility for being a partner with these communities, along with the great work being done by these NGOs in this space. And so I want to end by highlighting here, this is an example of Tombstone territory. This is an unincorporated community in Fresno County whose wells went dry during the drought. You can see them here learning about water accounting and water budgets in the GSP process. And I hope that we can see going forward more of this, not only in California, but around the United States as well. And thank you for your time.
Thank you so much, Jennifer. That's great, important lessons, I think, for lots of states and localities to take into account. All right, so next up we have Michael Lewin from Touro College. Michael?
Michael, you're on mute.
I think he's getting his PowerPoint up.
Okay, so go back to share screen. So let me start off. Can y'all hear me now? I'll take that as a yes. So let me start off with a little background. So over the past 10 or 20 years, most downtowns, or in New York City, I guess it'd be downtown and midtown, became more popular over the last decade or so too. So some cities, certainly most notably New York, but also to some smaller extent in some other cities like Boston, we've had some very, very, very expensive condos being built. And I talk, for reasons we'll discuss, it's primarily about condos. And some of these condos have been purchased by out-of-town investors, which involves some issues I'm about to talk about. And so the basic question is, to what extent given that these condos are often, or at least sometimes, being bought by out-of-towners rather than local residents who need housing, to what extent should zoning restrict or prohibit these sort of very large, very expensive buildings? And do they raise or lower housing prices? What? Oh, okay. So does this help? Is this what you're looking? So, oh, okay. Okay, so let me, I
Put it on
guess.
presenter view.
So, wait a minute. Share. I don't really see. Let's see. Share screen. Okay. I don't see. I don't see slideshow here. Let's see. View. Is it? I see speaker view, Valor gallery view, full screen. I don't see anything for slideshow. Okay. I'm just looking for, let's see, is there a slideshow? Let's save. Okay. So you may be, let's see. Okay. Okay. So can you all see the PowerPoint? Okay.
Why don't you share your screen again and then just keep talking and we'll just see
sorry.
it in your view.
Okay. Okay, so just for a little background, for a little more background, excuse me, you may be wondering, like, how is this even relevant to sustainability? And so I'm getting to the big picture and getting back to the big picture. So the reason is downtown growth or urban growth is more environmentally friendly or sustainable, to use common lingo, than suburban growth. That is to say, if you live in a city, you're likely to drive less, you're likely to live in smaller spaces than you otherwise would. And to the extent this affects housing prices and housing shortages, high housing prices reduce people's ability to live in these kind of walkable, transit-friendly neighborhoods, which in turn means more driving, more pollution, and more greenhouse gas emissions. So the issue that this paper is going to be about is, how does this high-end housing affect housing prices and housing shortages? So the traditional economic view is that the law of supply and demand applies to housing, and that more housing supply equals lower housing costs. And so, for example, we've seen after COVID that as demand has declined in Midtown Manhattan, where I live, rents have gone down too. So logically, more construction, no matter how expensive it's going to be, will at least have some positive effect in reducing housing prices. However, there's a counter argument, which is what my paper is primarily about, that the law of supply and demand doesn't apply to these highly expensive condos. The argument essentially is that this kind of new housing, because it's so expensive, is likely going to be soaked up by rich investors who never use it, rather than by local residents. And so therefore, this is really an argument. This is often used as an argument not just against allowing these very expensive condos, but sometimes even as an argument against allowing new market rate housing generally. And the PowerPoint includes some quotes that are examples of this mentality. So my article is primarily designed to critique this anti-condo argument, and it's really based on three assumptions. Assumption number one is that this new housing supply will invariably be occupied by out-of-town investors rather than by local residents. Number two, these out-of-town investors don't rent out the new housing, because if they did, that would mean the condos would actually increase the housing supply no matter who owned them. And then number three, if the new housing was not permitted, these out-of-town investors would essentially disappear or go someplace else rather than just purchasing the older housing and bidding up the price of that housing. And my paper argues that all three of these assumptions are wrong. Specifically, so one question is, well, is this housing actually purchased by out-of-towners? Actually, see, there's a typo there, sorry. So the only study I've seen in terms of who actually purchases it claims that 2/3 of downtown Boston's most expensive units are occupied by non-residents, or purchased by non-residents, excuse me. But even if that's true, obviously 1/3 is occupied by residents. So that means even if none of these units were rented out, they would increase housing supply to some extent, even if not as efficiently as other possible units. Number two, I would add, these super expensive units are really a small part of the overall new housing market. So for example, even in Manhattan where I live, only about 10% of the most recently built condos for sale are so expensive that they would be especially attractive to out-of-town investors, but not attractive to ordinary local rich people like law firm partners. More importantly, many of these units, possibly most of the units, are in fact rented out to local residents. So in a London School of Economics study, for example, it claims that only 1% of a pool of super high-end condos are actually left completely empty. That most of them are either used for a significant amount of time by the buyers, or they're rented out. The majority of them may actually be rented out to London residents. And of course, as I go on to say, well, more study is needed for data in other cities, but at least this survey suggests that these units often are rented out, which makes sense, because if you're an investor buying housing, why would you leave money on the table by not renting it out? And then the third issue is, well, let's suppose this new housing was forbidden. What would happen to that capital that's floating around looking for housing investment? Well, perhaps it would go away and perhaps they would go into the stock market, but it seems to me more likely that these investors might just purchase more desirable old housing, which would mean that the demand for this older housing, these existing luxury units, would increase while the supply would, of course, be stable, which, of course, would mean that prices would go up. And I raise a few arguments, but my primary argument is really just a matter of simple economic rationality. If you're an investor interested in making profits from real estate, especially if you're not interested in living the unit, why would you care whether the unit is older or newer? That is to say, if you just want to make money on housing in a booming housing market, a condo built in 2019 is really the same as a condo built in 2005. And if the second condo is cheaper, you can just buy more of them. So my bottom line is, even if it was true that every single new condo in Manhattan was purchased by an out-of-town investor, which is almost certainly not true, some of these condos would increase demand with supply by being rented out, and others would increase supply by reducing demand for the existing housing stock or for the older housing stock. So let me just mention one kind of side argument I address in my paper in more detail, which is that even if new housing is to some extent used or purchased by local residents, upzoning to permit such housing raises land costs. So more broadly, there's an idea that really any new housing or any pro-housing zoning increases land costs by making land more desirable. So there are at least two flaws in that argument. Number one, higher land prices shouldn't lead to higher land costs if developer is allowed to build more housing units per piece of land. In other words, if my land is worth twice as much, but I can build 4 times as many condos, each unit would cost less than it would if I couldn't build as many housing units. And then the second argument is, if upzoning increased prices, then logically downzoning would lower prices. But we've seen quite a bit of downzoning in various metros. So the classic example, or at least the most exhaustively documented example, is Los Angeles. In 1960, Los Angeles was zoned for 10 million housing units, so several times its population. Today, it's zoned for about a little over 4 million housing units, which is almost as low as its current population, only maybe 20 or 30% more than its population. So if downzoning reduced land costs, then Los Angeles would be getting cheaper. But both land and housing in Los Angeles keeps getting more expensive, just as is the case in some other cities. So finally, and this is just to add kind of an update to some questions that I hadn't really addressed in the original paper, but I might think about later on. Well, how does COVID-19 affect this? And how does the aftermath of COVID affect this? And of course, the right answer is we don't know. No one really knows anything. But possibly there could be a decline in demand for urban housing or for high-end urban housing. So it may be that this issue just becomes less relevant because there might not be the demand for developers to build these kind of buildings anymore. So if that's true, of course, there's no policy issues to argue about. One other issue is what happens as vacancy rates in these existing buildings we already have rise? How's that going to affect the housing market? So my suspicion, as we've discussed, is generally any decrease in demand is going to reduce housing prices. So in fact, these condos will be more effective in holding down rents than they were before COVID, or focusing more narrowly on the pool of buildings that's super expensive, which in Manhattan, I'm saying, let's say for the sake of argument, over $10 million, it's probably such a small part of the market that is not going to have maybe such a major impact. But to the extent it does have an impact, that impact will be positive in the sense of reducing rents, reducing housing prices. So by and large, I'm generally pro-building, pro-housing in this context. And that's all I have to say.
Thanks, Michael. So we have time for maybe a question or two. So I'll start. You mentioned this idea of luxury housing. You seem to set a pretty high bar, but I feel like people throw around that term a lot just to mean any new condo building. And so do you think there's a distinction there in terms of both how people are using the term, and does it affect your analysis if we're really talking about $10 million buildings versus $800,000 buildings?
Right. I mean, I think absolutely luxury is often used as just a pejorative term to anything new that isn't for poor people or it isn't government subsidized. I think the reason I focused on the very, very high end is because it really involved this interesting argument that doesn't really apply to kind of ordinary semi-luxury buildings, right? That is to say, if you have, if you have an apartment building that rents for $4,000 a month, and that maybe a young law firm associate would rent in, we can argue about whether that's a good thing or a bad thing, and I lean towards the view that it's a good thing. But it doesn't really involve this whole argument about out-of-town investors, because no one's going to seriously claim that out-of-town, rich Russian oligarchs are running around renting up $4,000 studio apartments, whereas people are making the argument that $10 million apartments are likely to be bought up by foreign oligarchs. So it's just, in other words, in the context of the super high-end apartments, there's this whole argument about vacancy that doesn't exist for the more ordinary, quote-unquote, luxury housing.
Yeah, I don't know. I guess I would argue, New York, I think sometimes can skew things. In Portland, Maine, buildings that are selling for $700,000, people make the same arguments and say it's retirees. They're only coming for a few months a year. They're empty most of the year. So it should be interesting to consider some of those ideas too.
That's an interesting point. I didn't really think about that comparison of the retirees to the tax evading Russian zillionaires.
Right. Right. A little different, but maybe some similar issues. All right. So our final presenter in this first panel is Michelle Oko from Duke University School of Law. Michelle.
Yes, hello, good afternoon. So I will be talking today about a provision of law in North Carolina known as the Hardison Amendment. And that is codified under North Carolina General Statutes 150B 19.3. And it is part of our Administrative Procedure Act. And just in general terms, it's a provision of law that prevents state agencies from passing regulations that are more stringent than federal environmental regulations. So essentially, the state of North Carolina has created its own ceiling that, prevents it from really going beyond the protections that are available under federal law. And part of what originally brought my attention to this issue was in relation to, the Trump rollbacks. There are many that were environmental, and really kind of looking at the state's role as far as protecting the environment and whether or not it would have the capability to do so based on this provision. So one of the difficulties, though, is even beyond the Trump administration, this amendment, this provision of law is very significant, especially when we look at how the role of states and how the states are really in a position where they can better adapt to the needs of their local population. This is especially relevant in the area that I focus on, environmental justice, which has a tendency to look at a lot of issues of equity. And when we look at specifically health disparities. So just very briefly, I wanted to give you a quick overview of kind of the history of the Hardison Amendment. So, this current provision is actually the second iteration of the Hardison Amendment. Actually, it was originally passed during the 70s and actually consisted of several different provisions of law. And those provisions were known as the Hardison Amendments because they were the major proponent of those provisions was Senator Harold Hardison. But the tide started to shift in the 80s and 90s, and piece by piece, the Hardison Amendments were repealed until ultimately in 1995, they were repealed completely. Then in 2000, and during that period of time, North Carolina was, as far as environmental regulation, there was kind of more action than what we're seeing now. But then in 2011, that's when we come to the point of having the current provision that I'm talking about as far as the Hardison Amendment under North Carolina General Statutes 150B 19.3. And there have been some attempts to actually repeal this provision of law. In fact, in 2018, House Bill 968, that was attempted, and that was a bill in relation to our state's attempt to regulate Gen X. However, that particular provision did not go into law. And one of the things that is the most disturbing about the Hardison Amendment is actually there's no case law really interpreting this provision. In fact, more of kind of what I've been seeing in my research is that it seems to be having a chilling effect where our state agencies aren't even stepping up to the plate to try to put forward anything that may be challenged. So I thought it was really, and that's another area of really kind of where moving as far as building my research is to really kind of empirically demonstrate those areas where that chilling effect can be verified. But one of the things that really kind of brought this issue to be significant as far as what I want to discuss today is that chilling effect and how it creates that cloud of uncertainty. But from my understanding of this legal provision, it really shouldn't. I mean, one thing is, I gave you the very brief overview, but I really see the Hardison Amendment as having essentially, 5 requirements, all of which need to be met in order for them to actually be a prohibition on a state agency's action in that area. So for one thing, if you do look at the provision, and I'll very briefly just kind of show you what I view as those provisions, you will see I've outlined the 5. So the first one, and actually let me go ahead and do this so that you could actually see much bigger. The first one is the agency. So the agency that we're concerned about, it needs to be one of the agencies that's actually listed under the statute as being authorized to implement and enforce the state and federal environmental laws. It has to, second, be adopted for the protection of the environment and natural resources. Third, it has to be more restrictive than an existing federal law on the subject matter. And then fourth, right, the federal law needs to be less restrictive than the one we're talking about that's more restrictive and actually have been adopted. And then fifth, the more restrictive rule must not be a required response to one of the 5 situations that are delineated in the statute. And I'm going to discuss each of those with you a little bit more in greater detail. So the first one, as far as the state agencies, under the statute, it lists 9 state agencies. And those are the Department of Environmental Quality, the Environmental Management Commission, the Coastal Resources Commission, the Marine Fisheries Commission, Wildlife Resources Commission, Commission for Public Health, Sedimentation Control Commission, North Carolina Oil and Gas Commission, and the Pesticide Board. So those are the 9. So for one thing, when we're going through and we have concerns, the agency would need to be one of those 9 agencies. And the second point that I brought up as being required under the statute is that it has to be for the protection of the environment and natural resources. Now, one of the difficult things is we have to go by the ordinary meaning because we don't really have the clarity as far as what is meant by environment or natural resources. That gets trickier, right? Because, like, for example, I brought up the issue of Gen X. A lot of that focus and about the regulation of Gen X and other PFAS, you're really looking at issues of public health. And it raises the question of what about those statutes that are those regulations, that are for the protection and promotion of public health, as we see as the whole purpose of the Commission of Public Health. So one of the challenges that I think is very important is to look at those, if a regulation is actually for the protection of public health, as opposed to focusing specifically on the environment and natural resources, then what are the limitations of that amendment? And really seeing agencies stepping up to put forward those provisions that are protective of human health. Because we know there's a human environmental feedback. We are not separate from the environment. We're part of our environment. We interact with our environment, and our environment impacts us. We impact our environment. So when it comes to health, and that's the focus, that really needs to be, I think, expanded and to see more rules of agencies actually taking steps to protect our health. Now, going to the third point, and about the rule actually being more restrictive than an existing federal law that's on the same subject matter. For that particular issue, what the kind of one of the challenges there is there's that cloud that exists about whether or not a rule is actually more restrictive if it's not exactly on point of that type of regulation. So, for example, if we're looking at, effluent standards, right, as opposed to actual contamination levels that you might see in well water, where would that be along the same lines of being a more restrictive regulation when they're actually regulating 2 different aspects? But then that also kind of ties into that subject matter issue, which we really don't have clarification on, hence that cloud. Now, I pulled out the 4th aspect because one of the things that I was also seeing when I was looking at the effects of the Hardison Amendment was almost a fear of proposed regulation and really feeling like that was going to prohibit the development of a state regulation. So that's why I thought it was important to really pull out that federal rule actually needs to be something that's in effect, that's actually adopted, not something that's theoretically being discussed as a potential limitation. But then the 5th and final aspect is that we do have some exceptions. Now, interestingly enough, those exceptions have been kind of tightened in that the 5 exceptions that I'm just going to describe, they're going to be limited to temporary rules, which then need to be replaced with permanent rules. But those 5 exceptions are a serious and unforeseen threat to public health, safety, or welfare. If there's the second one, an act of the General Assembly or United States Congress that requires the agency to adopt the rules. 3rd, a change in the federal or state budgetary policy. 4th, a federal regulation required by an act of Congress. And then also 5th, a court order. So those are the kind of the 5 exceptions that exist under the statute. But as I said, those, over years have been tightened where you have to have a temporary rule before you could go straight into a permanent rule. And then you still have that cloud, right? Because the state agencies really kind of think of this as a limitation, a restriction, not necessarily having that tied into the serious unforeseen threat to public health, safety, or welfare. So, those are the provisions that I thought was really important to kind of pull out. And this is an issue that we kind of see in other states as well. I see I'm kind of tight on my time, but just very briefly, Arizona, Kentucky, and South Dakota, for example, are states that have rules, statutes that are, more general in their restriction of agencies' ability to pass regulations that are more stringent than federal regulations. But at the same token, kind of tying that into the importance of the state being able to take actions for the protections of its citizens' health is very important. And really to see with those statutes, many of them, for the most part, do not mention public health. That is not true with all of them. So, for example, I believe it's Mississippi or Missouri, but one of the states specifically delineates, public health as part of that boundary. But for the most part, they're really kind of focusing on environmental regulations and this discussion of public health. And as for a purpose of regulation, I think it really kind of broaden the approach to what regulations can be passed, even when you have these restrictions in place.
Great. Thank you so much, Michelle. That was excellent. And yeah, I do think this is definitely an issue that more states and people in states need to be thinking about. So thank you. So again, feel free to put comments in the chat. Presenters will be able to see those and respond to them. Now we're going to begin part 2 of our program. So I'm going to hand it over to my co-moderator, Keith Rizzardi. Thank you.
Good afternoon. Thank you, Sarah, for that terrific panel and for all your work helping me host and organize this event. I'm Keith Rizzardi. I'm a professor at St. Thomas University near Miami, and I have the honor of being the chair of the AALS Natural Resources and Energy section this year. I'm really thrilled with that first panel on specific examples of environmental sustainability that have been implemented by our state and local governments. And we've talked about things like water and wildlife and land use and some of the challenges that come when you try to have state and local governments engaged in these environmental sustainability conversations. In this second portion of our program, we're going to explore further the obstacles that are experienced by our state and local governments. We're going to have 5 presenters as we go, and then I'm going to give some wrap-up comments at the end. Our first presenter is Elise Burtenthal. Professor Burtenthal is at Wake Forest University School of Law, and she's talking about the alchemy of the public interest. Professor Burtenthal.
Thanks. I just want to start by thanking Keith and Sarah for organizing this panel. Thinking about the questions that they've posed has given me the opportunity to rethink and reframe a long-term research project in a new way. And I'm really looking forward to the panel presentations this afternoon. So as I was working on this presentation, I came across an article in the New York Times detailing yet another saga in the fights over water in the American West. And of course, it's a really familiar story. It's one that we hear about at least every few years. It almost always involves a city finding a way to drain a small rural town. But what struck me about this particular retelling was the author's assertion that these battles flare up not because of conventional wisdom that there's too little water in the West, but because water is in what he calls the wrong places. And every time I read something like this, I wonder, what does it mean to be in the wrong place? Why does this keep happening? Is it going to continue until we're living in a Mad Max sort of dystopia where water is more precious than gold, where livelihood, let alone sustainability, is entirely up for grabs? And what can these sort of stories teach us about the ways in which sustainability is or is not defined as a local objective? So these are the sorts of questions that motivate a multi-year research project in which I explore the cultural and historical factors that might promote or impede regulation of resources at a local level. It was an ethnographic project. It's grounded in interviews and participant observation. It's also a historical one, reconstructing regulatory change and stasis over time. And the paper I'm discussing today draws from this larger research project. What I'm looking at specifically here is the concept of the public interest, which I conceptualize as a technique for shaping and effectuating local regulation of natural resources. Now, we encounter the public interest as a central term in legal and political discourse, but still the concept of the public interest remains kind of fuzzy. There exists important investigations of the public interest as justification for government regulation, as a guiding principle for corporate decision-making. There's valuable discussions on the discursive construction of the public that makes up the public interest. But really, there's not much that investigates the public interest as a conceptual engine of legal change or like regulation. And this is in part because I think public interest is regularly assumed to be self-evident in meaning. It's giving us categories, capture theory, public choice theory, etc., without really giving us theoretical reflection on the concept itself. Too often, the public interest is posited as an explanation, rather as the thing that needs explaining. But probing the public interest offers a starting point, I think, for cultural critique of fundamental principles in American environmental governance. And it can help us explain enduring inequalities in control and allocation of natural resources. So let me just move from this abstract discussion to a more concrete description of my research. It's grounded in what we might call the Water Wars origin story, a project initiated by Los Angeles more than 100 years ago to take water from the Owens Valley in California, a sparsely populated, mainly agricultural area about 250 miles northeast of the city. Now, if you've seen Chinatown, if you've read one of the half dozen books about this project, you know the story pretty well. It goes something like this very quickly. LA goes into an economically depressed area, buys up land adjacent to waterways. Then it takes that water and redirects most of it into an aqueduct and sends it to Los Angeles to be used by the urban residents. Now, we know, of course, that state law creates the opportunity for LA to do this because law is what allows control over water through control over land. But that explanation, I think, is at best incomplete. It tells us only how LA technically managed to pull this off, not how it justified doing so or how it generated popular buy-in for its plans. Also crucially important to this story and to all these stories of cities that we are taking water that we keep reading about is that the projects of reshifting resources from one region to another, from the wrong place to the right place, depends on a particular way of defining the public interest. And what I show in this paper through a historical and cultural analysis of this relationship of this history is that the concept of the public interest has not just been shaped by courts and legislatures, but it's developed on the ground through discourse, process, practice, embedded within a particular society at a particular time. In the case of Los Angeles, the city is not deciding the future of an existing water and power system. Rather, it's building one from the ground up. Its residents and officials wrestle with these challenges during one of the most intense periods of city building, and they do so by distinguishing an urban center from its rural periphery, reconstituting the city's connections to the natural world. They do so by describing a vacant natural identity to the rural community of the Owens Valley, one that serves as a foundation for both the ideological and political interests of the city of Los Angeles. Now, set in the context of tensions between public and private interests in an ongoing battle for municipal utilities and municipal control over resources, what this story shows is the importance of cultural discourses in shaping what might otherwise be predominantly legal and political concerns. Subject to formulated beliefs in the continuing importance of rural and urban differences, residents of Los Angeles gain both a sense of who they are as a public and also derive actual material benefits in the form of water and power. In this process, Los Angeles makes a unique and I think uniquely urban contribution to 20th century discussions about the meaning of the public interest and the importance of rural America in sustaining urban growth. Through the city's efforts, the rural Owens Valley was formulated not so much as another place, but what we might call a non-place, a place that exists not through a defined space, but rather only is linked to and interdependent with this emerging urban power. The possibility of the rural non-place, somewhere that's devoid of culture but full of nature, is made to never be absent from the reality of an urban place, a non-place that exists only to produce not as an organic society of its own, but to support a public presence and an interest firmly located in this urban center. The positioning of the rural as a non-place complicates efforts to achieve equitable distribution through legal means. To define the rural as a non-place is to erase its boundaries and its borders. In short, to eliminate the jurisdictional markers that serve as the prerequisite for application of the law. So LA's formula for the public interest subsists not only as a cultural expression, but as a mode of lawmaking that operates outside of courts and legislatures to inscribe an ideal version of sustainability in the Owens Valley in an idealized people who can benefit from the imagined summation of the valley's resources. And it's important to note that this formula that I'm describing here isn't unique. It reflects a broader historical pattern. As American municipal power expands in the 20th century, city officials working at multiple levels, social and legal, regional and national, work to ensure that local control inures to urban centers. As the engine of urban growth, public utilities working as a branch of these municipalities drive this expansion, forging a path for the urban public and directly contributing to a deepening disparity in access to resources between urban and rural communities. Now, understanding the role that local government plays in creating and justifying these disparities helps to explain why those patterns have been so difficult to undo. One reason is clear. Cities help shape a legally salient concept of the public interest in ways that skew urban. It deliberately constructs a narrative of place, of non-place, peoples and non-peoples, assembling them into a self-serving formula to produce a public that's both needed and that it can control. So public interest then operates as both a sword and a shield. It's wielded to justify expansion of local government and put forth as a means to assert local control against centralizing forces. But this power of the public interest is not universal. It's instead harnessed by cities in a way that redefines the local, through formulation of an equation that allows urban populations to centralize power over water, land, and the unrecognized peoples around them. And what I'm sketching here is admittedly very broad outlines of a very complex and deep story. But I hope even when described at this level, these findings serve as a foundation for several points I want to make in the context of this panel. The first point is that we need to broaden the questions that we're asking in this panel here, to urge a focus not just on law, but on the cultural power, appropriation, and negotiation between groups, especially as they wrangle over legally significant concepts such as the public interest. To rethink local governance in this way complicates the prevailing idea that sustainability is just a product of governmental projects and laws, and reminds us that it also emerges through internal community logics and needs. Second, I want to motivate us to take a more critical look at localized environmental law, drawing attention, as I think this panel is seeking to do, to the obstacles facing those who rely on local and state government to promote a more sustainable future. I want to suggest that there are at least 3 such obstacles that we can identify through this story of Los Angeles and the Owens Valley. First, there's a definitional one. When we talk about local government, how exactly are we determining what counts as local? Because as the story of LA and the Owens Valley shows us, local can extend far beyond a particular voting jurisdiction. Consider, for example, the fact that Los Angeles owns about 90% of the private land in the Owens Valley, thus giving it control over the use and allocation of that land, even though Owens Valley residents can't vote for LA city government officials. So when it makes these decisions, are these local decisions? And if we are to measure sustainability, whose perspective do we adopt? Or in terms of my paper, which public is going to count? A second and related obstacle is the need to situate local government in relation to the vast web of vertical and horizontal relations it forms with other governments. When we talk about local environmental controls, I think we often do so by comparing it to the exercise of federal power. Our assessment of local decisions is in large part based on whether or not those seem better or worse than the federal alternatives. And this may be a good way for us to understand outcomes of local control. But as the LA Owens Valley story demonstrates, local is much more expansive than a single governmental entity, especially when it comes to regulating resources that go well beyond political boundaries. So when assessing local efforts, we need to be especially conscious of effects on other localities, and only then can we determine whether local action amounts to a net positive or a net negative. A third obstacle to thinking about local sustainability is that in asking about law specifically, we tend to lose sight of how these local discourses and practices give meaning to those laws. So this means that when we talk about sustainability, we should be concerned with how law works at the local level, but we can't focus only on the legal doctrine. We also need to attend to the institutions that those laws create and the ways in which those laws arguably fail to regulate such institutions. Being aware of how cities and states privilege some resource needs over other ones can lead to better strategies for countering the erasure of particular people and things in sustainability initiatives and projects. If we better understand how we decide what people, places, and even resources matter, we can begin the difficult work of unraveling the assumptions and interpretations that power imbalances in who and what gets protected, and which hopefully will lead to local environmental governance structure that's not only fairer and more inclusive, but also more effective. Now, it may very well be that we'll continue to read news articles like the one I described at the beginning of this presentation. It may be inevitable that resources are continually viewed as being in the wrong places, and that sustainable governance is defined as shifting them to the right places. But I think more critical analysis of what makes for a right or a wrong place, what keeps localities from recognizing them more equally, can go a long way to developing a truly sustainable and sustaining governance structure. Transformation of environmental governance systems requires more than just tinkering with current modes of regulating land and resources. It requires acknowledging this distribution of power that makes such systems sustainable, as well as how we might rewrite prevailing cultural narratives so as to make room for other publics, other interests, whether these are local or something else.
Thank you, Professor. I note the overlap between your discussion of public interest and the importance of collaborative governance that was previously addressed, and the synergies and the need for local government to be integrally involved in that discussion. I mean, who decides what is sustainable? Who decides how much is enough? And that seems to be a very local question. I'll take a moment for any comments to come in through the chat board if there are any. Okay, seeing none, we'll kick it to the next speaker. Thank you so much, Professor. Our next speaker is Professor Aaron Ryan from Florida State University College of Law, talking about the challenges of preemption and scale that we have when we look at environmental sustainability issues. Professor Ryan.
Thank you so much, Keith and Sarah, for the opportunity to be part of this forum for sharing work. So the project that I'm sharing, the Twin Environmental Law Problems of Preemption and Political Scale, is actually a chapter in a book that I think is coming out any day, Environmental Law Disrupted. And that's the book chapter that I gave to the group. I'll also be referring to some work in an article forthcoming, Privatization, Public Commons, and the Takingsification of Environmental Law. And just to provide a nutshell of context for the project, this book, Environmental Law Disrupted, is put out by the Environmental Collaborative, which is a group of environmental scholars that gets together every few years to talk about problems of the day and potential solutions. And in 2018, the problem that we were discussing was what appeared to be the systematic dismantling of federal environmental law. And so we met to talk about that problem and brainstorm potential solutions. And I was invited to participate on the basis of my environmental federalism work in the past. And so my contribution to the project, which is what I want to talk about today, involves kind of an observation of two serious problems and one set of solutions, all of which conveniently began with the letter P. So my first essay on this topic was called Brace for the 3 Ps, Problems of Preemption, Property Rights, and Political Scale. And in a nutshell, what I'm going to talk about today is these two problems. One, this project is sort of speaking directly to advocates for environmental protection in the absence of federal environmental law. So I should clarify that that's the perspective that the piece takes. And the first problem identified is to be aware of the increased potential for use of preemption, and specifically sealing preemption, partnered with the rollback of federal environmental laws to prevent state and local governments from taking up some of that regulatory space that's been freed up by the withdrawal of federal regulators. And I'll say a few words about the California waiver under the Clean Air Act as an example, or efforts to undo it. The second problem to be aware of is the use of property rights, the strategic use of property rights as a tool for entrenching deregulation by creating property rights to protect private rights in public commons that have been deregulated. And that is the piece that I took out of the book chapter and put into the Takingsification article that I mentioned at the beginning. And then the third P is really not so much is the problem of how to cope with the national level and international level environmental problems that need solving without the benefit of federal authority, how to cope with problems of political scale in an environment in which federal authority is lacking, but other forms of authority remain. And so I'll talk briefly about some possible ways to do that, involving uniform regional governance, a uniform sustainability code, perhaps like a uniform commercial code. We'll talk about the Sustainable Development Code that Jonathan Rosenblum has worked on, and propose even more ambitiously, perhaps coordinated private environmental governance, perhaps a model sustainable set of CC&Rs for use by homeowner associations as a means of moving forward on, for example, climate governance in the absence of meaningful federal authority. Now, I realize that my piece may become moot. It's hard to know. Maybe when we find out what happens today and in Georgia, it will be clearer. But I'm going to go ahead and present these ideas because I hope they're still interesting. So the first P is about preemption, and the piece deals with problems of preemption. The challenge, of course, is if there is, in fact, a rollback of federal environmental law, as there has been for the last several years, how do environmental advocates ensure that the effort to dismantle federal environmental law is not
Did we lose? We lost Professor Zoldan. Okay. Or actually, that was Professor Ryan. Okay, so what we're going to do is hopefully we'll get back to Professor Zoldan if she dropped off, or Professor Ryan if she dropped off, and we will move forward to Professor Zoldan, who's talking about the non-delegation doctrine and deregulation. Professor Zoldan is from the University of Toledo College of Law. We're happy to have you here and looking forward to your comments.
Thank you very much. Good afternoon. I'm Evan Zolden. I'm very pleased to present a work in progress, non-delegation, and the fragility of state environmental regulation. Before I begin, I want to offer my thanks to our organizers, Professors Schindler and Rizzardi, for organizing this program under these unusual circumstances. So my initial thought or insight, the one that prompted this research, is that the anticipated revival of the non-delegation doctrine at the federal level will have trickle-down effects on state regulatory programs. And during my research, I discovered that the impact will fall, perhaps most dramatically, on state environmental law. The first point I'll make should be relatively uncontroversial, and that is that a majority of the Supreme Court now favors reviving the non-delegation doctrine at the federal level. This principle suggests that there are constitutional limits to Congress's power to vest policymaking authority in other institutions, most notably administrative agencies. Although the court has invalidated only 2 statutes under the non-delegation doctrine, and not since 1935, recent changes to court personnel suggest that non-delegation, once declared a dead letter, is due for a revival. In particular, the 2019 Gundy case, the court narrowly upheld a broad delegation of authority to the Attorney General. In a dissent joined by the Chief Justice and Justice Thomas, Justice Gorsuch argued for a revival of the non-delegation doctrine. Justice Alito, moreover, concurred in the judgment, but made clear that in a future case, he was more than willing to join the 3 dissenters. So if you're counting, that makes 4 justices in support of reviving the non-delegation doctrine. And Justice Kavanaugh did not participate in Gundy, but he became the 5th likely vote for reviving the doctrine when he wrote a separate statement respecting the denial of cert in a case called Paul. In his statement, Kavanaugh indicated that he too was willing to vote to revive the non-delegation doctrine in a future case. Of course, Justice Barrett has since replaced Justice Ginsburg, and I'm not aware whether Barrett has made any public declarations about her views about the non-delegation doctrine. However, because the non-delegation issue, it seems to fall on traditional partisan lines, at least among Supreme Court justices, if not scholars, commentators expect that she will support efforts to revive the doctrine as well. So that leaves us with 5 or possibly 6 votes on the court for reviving the non-delegation doctrine. I think that part is relatively non-controversial, but the more interesting question is what shape the new non-delegation doctrine will take. Justice Gorsuch's vision that's laid out in Gundy is starkly formalist, drawing a distinction between, on the one hand, setting policy, which only Congress may do, and on the other hand, filling up details, which is permitted to an agency. Justice Kavanaugh's vision, sketched out briefly in Paul, suggests that the non-delegation doctrine can be read like a constitutionalized version of the major questions doctrine of statutory interpretation. It would require Congress to make policy decisions of great economic and political importance, but it would allow administrative agencies to address policy issues of lesser importance. Scholars have added a flurry of predictions and suggestions about what a revived non-delegation doctrine could or should look like. For example, the court might invalidate a large portion of the administrative state as unconstitutional. Or it might strike down broad delegations, but only within certain limited subject matters. Or perhaps it will invalidate just a single statutory provision for symbolic purposes or as a warning to Congress, but then otherwise refrain from policing broad delegations. Or the court might enforce the doctrine going forward, but leave in place the many cases upholding past delegations. So under most of these predictions, some major federal regulatory programs are vulnerable to invalidation. These include portions of key environmental statutes, including environmental health statutes like the Clean Air Act, the Safe Drinking Water Act, Occupational Safety and Health Act, among many others. But what has not yet been fully discussed is how the revival of the non-delegation doctrine at the federal level will affect state regulatory programs. As it happens, countless state regulatory programs are tethered to the existence of federal statutes because states often regulate by incorporating the language of federal statutes or regulations into state law by reference. State law incorporates federal law by reference in a wide variety of areas, including the types of environmental statutes I mentioned above. And importantly, many of these incorporated federal environmental statutes are those that are the most vulnerable to challenge under the scenarios in which the non-delegation doctrine is most likely to be revived. For example, some of the statutes are the very same ones that previously have been challenged at the Supreme Court on non-delegation grounds. Others use similarly broad language as these statutes. Still others appear to delegate authority in a way that is described as impermissible by Justices Gorsuch or Kavanaugh. Consider, for example, the relationship between the Federal Clean Air Act and state air quality standards. The Clean Air Act authorizes the EPA to set national ambient air quality standards. Many states incorporate the standards set by the EPA into their own regulatory programs by reference rather than by reproducing the language of the federal standards themselves or deriving their own standards. For example, the Pennsylvania regulations creating Pennsylvania's air quality standards provide that, this is a quote, the national ambient air quality standards promulgated by the administrator of the EPA under the Clean Air Act are hereby incorporated by reference. As a result, if the air quality standards provision of the Clean Air Act is invalidated, then there's a question about what happens to Pennsylvania's air quality standards. Do they just disappear? Do they persist in the absence of the law that they reference? Is there some middle ground? The answers to these questions will determine whether the coming revival of the non-delegation doctrine will invalidate not only federal environmental regulations, which is momentous of its own, but whether it will also upend state environmental regulations on the same subjects, leaving potentially dangerous gaps in the law. Just exactly how a revival of the non-delegation doctrine impacts state environmental programs that incorporate vulnerable federal statutes depends on how robust or fragile the state regulatory programs are. This robustness or fragility of state regulatory programs, in turn, depends on a number of factors, which I've been calling, for lack of a better term, conditions of fragility. So what are these conditions of fragility that will determine the impact of the revival of the non-delegation doctrine on state regulatory programs? First, state regulatory programs are more likely to be fragile if they incorporate federal law dynamically rather than statically. State law incorporates federal law dynamically if it incorporates federal law, including future amendments, rather than simply the federal law that exists at the time of the incorporation. If a state law incorporates a federal law dynamically, the state law will disappear when the federal regulation disappears. This is the case, for example, for many states' air quality regulations. Many states incorporate dynamically the federal ambient air quality standards, or at least the measurement methodology used written by the EPA in whole or in part. By contrast, if the state law incorporates the federal law only statically, it will not disappear when the federal law is invalidated. However, even if a state incorporates federal law statically, the disappearance of the underlying federal statute can create problems for the state regulatory program, particularly when the state relies on data that is created or updated by the federal agency. Second, whether state environmental programs are fragile or robust depends on how active a role a state played in policy formulation under the old federal regime. Some federal statutory schemes invite states to participate in policymaking to a great degree by giving them some power to shape the regulations they will be enforcing. These programs might be easier for states to replace because the states are already invested in the success of the program. For example, the EPA delegates primary enforcement responsibility of the Safe Drinking Water Act to the states, provided that they adopt certain substantive and procedural requirements that facilitate carrying out the purposes of the statute. As a result, states already have a lot of investment in the enforcement of the Safe Drinking Water Act, at least the vast majority of them that have primacy over enforcement. By contrast, other federal programs are more hierarchical, they're more top-down, so the states may be less committed to the continuing vitality of the program after the delegation disappears. Third, whether state regulatory programs are robust or fragile depends on the capacity of state institutions to regulate in the absence of federal law. Different states have different capacities for regulation, and the disappearance of federal law will affect them in different ways. For example, some states have full-time legislatures and professional committee staff. Many others have only part-time legislatures whose members are mainly occupied with their day jobs. States with full-time legislatures are better situated than part-time legislatures to replace complex regulatory schemes. Some state legislatures are term limited, while other state legislatures are not term limited. Term limited legislatures tend to have a difficult time accruing expertise and conveying it over time, which tends to shift power to professional lobbyists and other state institutions. Some states have statutory or constitutional barriers to regulation, like regulatory sundown provisions or their own non-delegation doctrines. State-level rules that prevent robust delegation of authority can prevent state agencies from replicating the research and other work necessary for complex regulation and enforcement. And finally, there are a host of other factors, too, that influence the state's capacity to regulate, including whether they have political or other non-expert bodies reviewing proposed rules, partisanship, and of course, perhaps most importantly, financial constraints. So in conclusion, the coming revival of the non-delegation doctrine at the federal level may have a dramatic effect on both state and federal regulatory programs, including environmental programs. However, it's likely that the effect on state regulatory programs will not be uniform across all the states or across all types of regulations. Instead, the effect of non-delegation on a particular state's regulatory program will depend largely on how the state relies on federal law, the state's investment in the regulatory program, the robustness of state institutions, and their capacity to regulate. Just add one final note. The coming non-delegation doctrine also has the potential to change the relationship among the states by empowering some states and disempowering others. States that are well situated to invest in technological expertise might become national leaders in environmental regulation in the absence of strong federal guidance. By contrast, states that are unwilling or unable to make this investment may find themselves beholden to research and standards set by their sister states. I'll stop there, except to say another thank you to our organizers. Thank you.
Thank you, Professor Zoldan, for that presentation, especially on short notice there filling in. You know, I notice again the themes that are emerging in our conference, and this time it's the federalism and the tensions that we have with are the governments cooperating? Are they competing? What happens when the states or the feds refuse to act or are unwilling to act or are unable to act? And I'm going to come back now that Professor Ryan has been able to rejoin us and let her share a little bit more on some of the overlapping concepts that she was getting into with the problems of preemption and scale. So welcome back, Professor Ryan, and hopefully this time we'll be able to go through seamlessly.
Thank you, Keith. And I apologize to everyone. I'm afraid it seems that this is the pandemic problem of unstable internet, but hopefully it will go more seamlessly this time. And thank you, Evan, for stepping in when I fell out. I'm going to try to go quickly through the beginning so that I can fit within the time that had been originally allotted. I'm just going to remind you I'm presenting mostly a book chapter. I am setting it to, hopefully my PowerPoint is now properly seated. I'm going to be talking about 3 Ps, two problems, one potential set of solutions, problems of preemption, property rights, and political scale as a response to the effort in recent years to roll back federal environmental law. And so this project comes from the perspective of advising environmental advocates how to move forward in the absence of federal environmental law. Where I had been speaking was about preemption. I'm going to cut back on that so I don't repeat what I've said and still fit within my time. I'll just say that preemption is an important part of environmental law, which partners local and national regulatory capacity in dealing with environmental problems at the local level, allowing local governments the capacity to bring to bear their expertise on local circumstances, but allowing national authority to set minimum and national environmental standards and police boundary crossing spillover harms. And that's the partnership between the different levels of government in environmental law. So preemption itself is not a bad thing in environmental law. It's necessary to create a national standard that, for example, allows all Americans to drink water from their tap. But there has been a threat, or at least one threat that I warned environmental advocates to be thinking about, is increased use of ceiling preemption. Normally in environmental law, preemption is used as a mechanism of setting a minimum standard. We would call this floor preemption, where the federal government says there must at least be this level of environmental protection, and localities and states cannot go below it, but they can go above it. They can exceed it and pay attention to things perhaps that the federal government is not paying attention to. There has been some concern that ceiling preemption may be on the rise as part of the effort to roll back federal law, environmental law, because if you roll back federal environmental law, but you don't prevent state and local government from taking up that space at the regulatory table, the deregulatory project will fail. So I won't say much about this. I was going to give an example under the Clean Air Act. The Clean Air Act has a singular example of ceiling preemption in environmental law, in that the EPA sets a ceiling and not just a floor for motor vehicle emissions, for example. But there has been an exception for California, which is historically led in motor vehicle emissions. It is able to regulate more stringently than the federal government, and states can follow the California standard. The example of ceiling preemption that is in the article that I won't belabor here has been an effort not only to roll back federal motor vehicle emission standards set under the Obama era, but to partner that with a reversal of the California waiver, effectively ceiling preempting all state regulations on motor vehicle emissions. And I think that's troubling. So in the article, I advocate for, or rather, I advise environmental advocates to resist ceiling preemption, to insist on savings clauses in regulations and laws that would threaten to preempt, and to rely on the presumption against preemption in litigation. But I think I will skip over preemption for now and move to the second P. And now I'll speak more slowly and hopefully have caught back up in my regular time. It's really interesting that if there's an effort, if one's goal is to deregulate environmentally, one thing you will be worried about is at the federal level, if you deregulate, but you don't effectively preempt state and local government will come fill that void, as they have in many states at many times in American history. But even if you preempt state and local efforts to provide environmental protection, it's not enough. If you're very concerned, you also want to worry about what future legislatures might do if they change the policy. So if you really want to entrench environmental deregulation, one really effective way doing that we should be worried about as environmental advocates is entrenching environmental deregulation through the strategic deployment of property rights. And this is an idea I credit to Christopher Serkin for first bringing attention to it in the literature. I'll just say a word about it. The problem is when the government acts in its sovereign capacity, the government can always change its mind. There's this conventional constraint on the use of the police power as a tool of regulation, which is that you can regulate in the now, but you can't bind future regulators. You can't bind future legislators. That is why that's a problem if your goal is to really make your deregulation stick. However, when the government acts in its private capacity by manipulating the tools of property or contract law, then we do enforce promises into the future, just like private parties. So the best way to entrench a deregulatory effort is to make it really stick, is to buttress the deregulation with the insertion of property rights in the formerly protected public commons. So if there's a public commons that you deregulate and you want it to stay deregulated, the best way to do that is to make sure that private parties get property rights in the former public commons. Property rights are really powerful. As we all know, they get an added layer of constitutional protection under the Takings Clause. So the recipe, deregulate the public commons, assign private rights to it. The private rights will now get enduring protection that future legislators can't undo. And we see lots of examples of that, especially in public lands with oil and gas leasing potential. In the last several years, there's been a rush to provide leasing opportunities on coastal lands, BLM lands. Yesterday, the Arctic National Wildlife Refuge was opened up for leasing rights after decades of controversy over that. And so the advice that I give in the piece is to push back both at the pragmatic level on an individual basis, but also at a level of property law theory. And that's the takingsification article, but I will not dwell there. I will finish up with the third P and talk about dealing with problems of political scale. So here, the problem is clear. How do we solve national level and even international level environmental problems without the benefit of federal authority? And think back to 2018, this is what we were looking at. If federal environmental law is off the table, how do we cope with things like climate change? Even if we can't have the first best solution, which even state and local governments who have led on climate change in recent years would all agree would have been a more encompassing organized national or international approach, how can we move forward without those tools? So it's not a rocket science answer, is uniform regional governance. We can try to, if we can't all agree to do something as a nation, we can try to agree in big blocks of regions to do something that in the aggregate will have an impact. It's a disappointing approach for many because the regulatory patchwork of environmental law had kind of failed in the 1970s, leading to the big environmental statutes like the Clean Air Act and the Clean Water Act. So why would we think that it failed then, but it will work now today? Well, instead of a patchwork of different approaches taken state by state, as was done in the past, what if we all adopted the same basic rule in all or most of the states? And so we have some widely applicable, widely adopted examples of that, the Uniform Commercial Code, the Model Rules of Professional Responsibility. So what if we tried for a model sustainable development code, for example? And there is such a thing, and we can credit this to the chair-elect of this section on state and local government law, Jonathan Rosenblum, who with Drake University and lawyers and planners and city governments and academics nationwide created in 2019 this really innovative tool. It's a database, it's a resource of rigorously researched model approaches for state and local planning, uniform tools to sort of think globally on scaled up sustainable governance while acting locally within one's own jurisdiction. It's designed to help local governments build resilient, environmentally conscious, economically secure, and socially equitable communities. And it consists of 32 subchapters with 900 some odd recommendations for specific objectives in these different categories of sustainable governance: transportation, green building, urban forestry, waste management, each one providing 30 to 40 concrete policy actions that governments can take to become sustainable in that area, with examples that are in use in other cities. And my chapter calculates what the results look like if you, for example, take some of these low-hanging energy and water conservation measures and scale them up. It's not nothing. Now, the last point I'm going to make in the presentation is to push this idea even forward a little bit more ambitiously and say, if we can't do it at the federal level and we can't get enough agreement or enough consensus at the state or regional level, are there yet other tools that we can think of to deal with large-scale environmental problems? And one answer here, credit to Michael Vandenberg for sort of leading on this realm, maybe we need to think about how to coordinate private environmental governance in ways we haven't done before. So if government isn't working, what else might work? Legal pluralism, for example, the literature on legal pluralism talks about the value of bringing multiple sources of normative authority to bear, not just sovereign authority, but normative authority in professional associations, religious groups, cultural groups. And one that really bears on our question, let's just take climate policy, is homeowner associations. A large volume of climate relevant decisions take place in people's homes. And a large number of homes are privately regulated by homeowner associations. 1 in 5 Americans live in a servitude governed common interest community. So by combining the insights of the Model Sustainability Code that we just saw from Jonathan Rosenblum and maybe what we know about servitude laws, maybe we could create a model homeowner association sustainability code for private development. We know that homeowner associations lack expertise pretty famously, so maybe we could provide it a set of a model code that encourages sustainable, say, landscaping practices and discourages some of the practices homeowner associations are famously bad at, like discouraging or preventing solar panels or composting or line drying. So this would be an effort to try to get environmental governance to scale up from not just the bottom up in terms of governance, sovereign governance, but the bottom up in terms of vehicles of other coordination. And I will stop there since I've probably exhausted my time. But thank you for a second shot.
Thank you, Professor Ryan. We're glad we were able to accommodate that second shot. And what I think I'm going to do is look for questions to come after we get to the end of this panel. Thus far, we've given a lot of thought to overcoming the barriers, and that these barriers reduce the state or local role in environmental sustainability. And we've got these problems of preemption or deregulation or property rights or the scale of the issue. Professor Heidi Robertson from Cleveland State University has a different idea. She wants to use rights of nature as a tool to create and compel change. So, Professor Robertson, I'll turn it over to you.
Sorry. Okay. Thanks so much, Keith and Sarah, for inviting me to do this and organizing. And I wouldn't say it's so much that I want to use rights of nature this way. I think what I think is going to come out, in the presentation. So several years ago, I served on a regional commission, the goal of which was to recommend how local governments might exert some control over the oil and gas activity-related decisions that could affect their jurisdictions. My projects have expanded beyond oil and gas-related decisions, though, to include local government efforts to affect the environment more broadly. And one common thread throughout my work has been the topic of this program, that is, to consider the various obstacles that local governments face in trying to affect their environments and the paths they've taken to try to circumvent the obstacles. So let's start with a quick look at a couple of obstacles. We could talk all day about the influences corporate interests have over some state legislatures. For example, 2020 revealed the explicitly corrupt influence of First Energy Corporation in Ohio. First Energy and the oil and gas lobby were in paid cahoots with the leadership of Ohio's legislature, who pressured their peers and won passage of bailout legislation for some failing First Energy power plants. Truly, the FBI swooped in, charges were brought, arrests were made, and the Ohio legislature still has been unable to repeal its tainted legislation. Next, let me go on to the next slide just for a second. Second is state preemption, which you've heard more about, and I'm just going to say something quick about it, which is it's obviously a major obstacle for local jurisdictions to act to protect the environment. And I'll use the preemption provision in Ohio's oil and gas law as an example. As shale production moved into Ohio, the Ohio legislature passed serial amendments to the oil and gas law to increase the state's preemptive grip over local decision making. I'm sorry you can't see the precise text of this slide, but it highlights a series of 3 amendments over a 1.5 year period in which the legislators just kept going back to the preemption provision and adding to the list of activities and decisions over which the state DNR would have sole and exclusive authority, and to further tighten its grip on decisions over which local governments would have no role. And this is just an example. It's happened in many areas over which the state asserts the need for a unified system of regulation or control. Last, and this is the obstacle I'll focus on today, and that is proponents of environmental protection, whether they are citizens or local governments, often lack standing in U.S. courts to protect the environment. And until recently, there was little support for the idea that nature should have standing in its own right. Citizens and local governments are frustrated by their inability to act to protect their own environments. Their voices are small and they are ineffective. They've been outspent and they have been preempted. So in this cartoon, which refers to Toledo's Lake Erie Bill of Rights, which I'll discuss soon, you see big agriculture with an Ohio General Assemblyman literally in his pocket. But you could easily replace the big agriculture moniker on the big guy's shoulder with big oil or big industry of any kind. So these and other obstacles to local action have caused deep frustration for local governments and their citizens. And I saw that working on this regional commission. The obstacles have contributed to their seeking alternative forms of action to protect their environments. In Ohio and in many other parts of the country, Colorado, Pennsylvania, New Mexico, and others, one increasingly prevalent alternative form of action is the Community Bill of Rights. Community Bills of Rights, or CBRs, grant rights to nature itself and to citizens to enforce those rights on behalf of nature. Sometimes instead of granting rights to nature itself, they grant rights to citizens to a clean environment. Today, I'm mostly talking about the former, those granting rights to nature. Rights of nature theory is commonly traced to Christopher Stone's article, where he argued that just as the law evolved to recognize legal rights for children, women, minorities, non-human entities like corporations, the church, nation states, so too should the law evolve to recognize rights of natural objects and resources. Stone's central argument is that by limiting the justiciability of environmental harms to rights-bearing persons or the acts of state agencies, there remains a world of deleterious conduct that survives unchallenged. By granting legal rights to nature, and therefore also standing in courts, those harms may be better controlled. So U.S. governments, local governments, and citizen groups have seized upon the concept of rights of nature to find their alternative avenue for local control or influence, specifically to try to create standing. Although the concept of the rights of nature has been roundly rejected in U.S. courts as an avenue for standing, I do find it notable, that even important, that local governments and their citizens persist in enacting them. And despite Stone's article in the early 2000s, the idea of giving rights to nature remained on the fringes of environmental legal theory and of public consciousness, certainly in the United States. But today, those rights are being granted around the world. The problem of lack of standing for nature may be changing, and examples from around the world may provide some lessons on how standing and rights for nature might work to help local governments act. Ecuador, for example, the Constitution now provides rights to nature, rights to all of nature, and universal standing to people to sue on nature's behalf. New Zealand's 2017 Rights of Nature statute provides individually granted rights to natural resources. But distinct from the rights granted in Ecuador, New Zealand grants rights specific to a particular named river, the Wanganui. Learned to say that. And New Zealand legislatively designates representatives with authority to enforce that natural resources right, in particular to a committee that includes representatives of the Crown as well as of Indigenous groups. So I'm thinking there are two important distinctions here in just these two international examples. And I hope to discover which approach has more promise for local governments in the United States to help with this problem we've been discussing. The first distinction lies between the rights granted to nature, sort of between rights granted broadly to all of nature, as opposed to rights granted to individually named resources. The second distinction lies in efforts that grant broad standing to all people to enforce the rights of nature versus rights limited to designated enforcers, like we saw in New Zealand. So I'm going to just take a second and look at a noteworthy example from Ohio. I hope I didn't miss one. Yeah. And here are some photos of the harmful algal blooms that occur in the western basin of Lake Erie, caused drinking water bans and led Toledoans to enact a community Bill of Rights. This CBR, the Lake Erie Bill of Rights, or LEBOR, purported to grant rights specifically to Lake Erie, which puts it in my category of rights granted to individual resources, and made LEBOR unique in the United States in that regard. Because LEBOR designated Toledoans broadly to serve as trustees of Lake Erie's rights and the ability to sue on behalf of the lake, I put LEBOR in the category of broad or universal enforcement authority. Most U.S. jurisdictions have asserted those rights for all of nature in their jurisdictions. Here's just some examples. Only recently has the U.S. jurisdiction, like I mentioned, Toledo, Ohio, asserted that an individual resource, Lake Erie, has rights of its own, like the rights New Zealand granted in the Wanganui River. Interestingly, internationally, we see movement more towards the New Zealand and Toledo style CBRs, granting rights to named specific resources. Most CBRs in the US grant enforcement authority to anyone. To my knowledge, we have not yet seen any US jurisdiction follow New Zealand's lead in the second distinction by granting enforcement to a designated body, limited body of people. So around the world, we're seeing more nations following New Zealand's approach, granting rights to nature broadly, but not granting rights to nature broadly, but more to individually named resources. And again, there are many examples. These are just a few. But surprise, not really a surprise, LEBOR was struck down in federal court as unconstitutionally vague and as exceeding municipal authority. And the judge went further, though, suggesting that an ordinance like one enacted in Madison, Wisconsin, might be able to pass muster. The city of Toledo declined to appeal, so LEBOR itself is dead in the water. But still, as I've said, even since the demise of LEBOR, local governments continue to adopt community bills of rights. And they're not dumb, they're frustrated. Understanding that community bills of rights are out there, they're persisting, they're evolving, but that they've been unsuccessful in courts to date, I thought I'd take a minute to talk about some positive movement against these obstacles to local action that we've seen occurring in states and in tribes. And I'll start with Hawaii, where the state constitution says each person has the right to a clean and healthful environment, and any person may enforce this right against any party. Well, since 2007, the Hawaii courts have effectively said that plaintiffs must still meet a standard 3-part standing test. But the difference is there, the harm shown may be to plaintiffs' environmental interest as injury rather than actual injury to the plaintiff. And there will be no requirement that their asserted injury be particular to the plaintiffs. So that's a step. Connecticut law grants people standing to sue to protect the public trust in air, water, and other natural resources. And the courts have interpreted this only to require a colorable claim of harm to natural resources. So again, a glimmer of hope in the states. Here, the Ho-Chunk Nation was the first tribal nation to amend its constitution to grant rights to ecosystems. And this one here, the Yurok, grants rights to an individual resource. So thoughts for for local governments. Many tribes and quite a few states have made it easier for citizens and local governments to achieve standing to sue to protect the environment, and some of them are receptive to the idea of rights of nature in its own right. Home rule constrictions continue in many states. Theoretically, these constrictions violate some core principles of conservative legislators, but apparently not when it comes to big oil or big agriculture. The rest of the world is moving quickly and in a manner that is protective of natural resources and inclusive of citizens. We could follow their example. Finally, a vocal citizenry can be effective. Toledo citizens passed LIBOR, only to have it struck down in court, but they got it passed. And the continued interest in community bills of rights suggests that rights of nature are gaining traction. And perhaps that traction should be used even in the nearer term to push for the inclusion of environmental rights in more state constitutions. So those are my thoughts for the day. Thank you very much to everybody for your time.
Thank you, Professor Robertson. It was a great presentation and really thought-provoking. And our next speaker is going to add to the productivity and those thought-provoking ideas, because we're going to talk about an often overlooked issue. What happens to history when we have this conversation about environmental sustainability? What role do the state and local governments play in ensuring that when we are rebuilding or repairing or renovating, especially after we're dealing with resilience issues and hurricanes, what happens to our heritage? And Sarah Broden from the University of Connecticut School of Law will be talking to us about these issues. After Sarah, I'll be looking for comments and questions from folks, and you are welcome to please post those in the gallery in the chat room. Thank you. Sarah, let's hear from you.
Hi, everybody. And thank you for enduring to the very end, even as we have disasters unfolding around us. I feel like my topic today on disaster law is particularly appropriate, unfortunately. So anyway, I wish we were all together in person. Thank you so much to Keith and Sarah and everybody who worked to arrange this panel. So I put a link in the chat to the paper that I'm talking about today, and just to try to keep things short, I'm just going to give some really high overviews of different things that I talked about in the paper. I would love to get some additional comments offline or in the Q&A. So the paper is called Law's Disaster Heritage at Risk, and it was an invited paper for a collection that's forthcoming at one of the Cambridge handbooks on disaster law. Ryan Roberry, who's one of my co-authors, invited me to do a paper on historic preservation. That's a shared interest of ours and something that is understudied, as was just mentioned. When I started looking at the topic, I thought, okay, this is going to be really straightforward. I've heard here in Connecticut, where I live, there's a lot of incorporation of historic preservation into disaster response. We've been hit by a number of disasters, hurricanes in particular, over the last few years. And so we've gotten kind of good at understanding what historic properties, we value historic properties, and we've gotten pretty good at incorporating them into disaster response. But as I kind of delved a lot more deeply into this area, I realized that this is one of those really interesting conundrums where federalism and politics and I guess really, maybe at its core, a lack of understanding of the value of history kind of comes into play. So with that background is why I started on this project. I just wanted to talk just about, again, the basic dimensions of it. And the first thing is, why does this matter? How do historic properties have anything to do with disaster? So, of course, historic properties are a finite resource. They run the gamut from archaeological sites to buildings to battlefields. Any place where there has been a significant event, person, architectural style manifest or information important to prehistory, these kinds of places have legal protection as designated historic sites in the area of historic preservation law, which is the area of law I'm much more familiar with than disaster law. It is the designation process and the identification of sites as historic that gives them some protection across the board. In theory, they also have protection through disaster law, because federal disaster law requires in a number of ways, and I go into more detail in the paper, for historic properties to be taken into account when a disaster occurs, or before, during, and after disaster occurs. However, while that may be the case on paper, in reality, it doesn't really seem to be working that way. And so in the paper, I go through 3 different levels of government, federal, state, and local. Tribal law is an area of law that I wish I knew more about and had more time to explore, because that I think could be another fertile area of exploration. But I'm going through federal, state, and local law. You really start to see that there is a big lack of coordination in this area in a number of different ways. So let's just take the different stages of a disaster in very high level detail. So before a disaster, planning for a disaster, how might you go about planning for a disaster if you're a community with resources that you want to protect? Well, in the first instance, you might try to figure out what those resources are and how they are at risk. In the historic preservation world, there is a severe lack of data and information about places that are valuable. There is no unified database of even historic places designated on the National Register. Even most states don't have lists, unified lists of historic properties, much less GIS maps of those. And at a local level, with about 2,800, maybe over 3,000 local historic districts across the country, or cities with local historic districts, again, those historic districts are not mapped and certainly not coordinated. If you don't actually know where your historic resources are, even the ones that have achieved the level of designation, which is not even counting the ones that haven't achieved that level but are still worthy of protection. So if you don't know where any of those are, it's impossible to know how to protect them. In addition, if you don't know what specific risks might it might exist for these historic properties, it's equally impossible to protect them. And by risks and by disasters, what I'm really talking about in the paper are everything from flooding to increases in rapid increases in temperature and moisture, wildfires, earthquakes, really the range of what some people colloquially refer to as natural disasters. But as I've gotten into this area of law, I've been told you can't say natural disaster because no disaster is natural. It's really simply the conflict between natural phenomenon and human settlement. So anyway, in the case of before disaster, our laws don't do a good job of requiring us to catalog our resources, to coordinate an assessment of risks, and to really understand what is at risk. During a disaster itself, the integrity of the historic property is really what is at issue. And in order to protect the integrity of a historic resource during an event, a weather event, a disaster, you really have to usually have done something in advance, whether it's raising a historic building, possibly moving it out of an area where you might experience wildfires or flooding, and known to experience those things or vulnerable to those things. You might modify the materials or cover it with a chemical treatment that would prevent, let's say, moisture. So none of these things that I just mentioned, none of these potential treatments are actually sanctioned by a standard that's enshrined in federal, state, and local law called the Secretary of the Interior Standards for the Treatment of Historic Properties. So we have at the national level in historic preservation law a set of standards that talk about how you can treat historic properties. Those standards don't take take into account really even very basic things about climate change, but certainly not the threats of disasters that are on the horizon in a number of different ways for our historic resources across the country. So during mitigation, the Secretary's standards and what you can do to historic properties to protect them from harm, totally missing, no coordination whatsoever. And then finally, after a disaster, recovery. So there are a number of programs, including the National Flood Insurance Program, FEMA laws and regulations that address recovery. And at least on the FEMA side, again, they say historic preservation has to be accounted for during recovery. But when you get to the level of state hazard mitigation plans, only about 32 of them incorporate historic preservation into hazard mitigation planning at all, much less incorporating historic preservation professionals in the situation room after a disaster. Again, here in Connecticut, we're a little bit more prepared for that. We are the land of steady habits. We love our historic resources, and we have found a way to incorporate historic planning and professionals during recovery to some limited extent. And that's why Connecticut is one of the examples, along with Louisiana, that I cite in the paper as, maybe doing a better job at this than most states. But even those couple of states I cite, really haven't fully integrated how we treat historic properties after a disaster into their protocols. And probably one of the most prominent examples of this is New Orleans and what happened after Hurricane Katrina in the Ninth Ward and other historic places where you saw just a total kitchen sink approach to those resources and their recovery. So just thinking about the three stages of disaster, and again in the paper I sort of weave through lots of different areas of law, historic preservation really being a standalone area of law that has its own standards and protocols and not really merging into disaster law. So, I guess I would say, just to close out with a few observations, this is federalism at its finest, federalism at its worst. If one of the goals of federalism is to prevent is to allow 1,000 flowers to bloom. Well, that's certainly happened here. But if we do, as a society, value these historic resources that we've gone through the trouble of designating and gone through the trouble of establishing standards for, and in fact have value to us, even from an embodied energy perspective, when it comes to existing buildings, perhaps we should consider a more unified and more robust approach to these areas. Right now, it's extremely siloed. Right now, the major focus has been flooding to the extent that disaster has been encompassed in both areas. Those integrations have really focused on flooding and not other areas of law. And so, the flood insurance program, which also focuses obviously primarily on flooding, should potentially be expanded to other areas where we know there are quantifiable known and increasing risks of certain hazards, including again, wildfires probably being the most quantifiable among those. So I think I'll just leave it there and just say I really value comments on this paper. I really enjoyed the other presentations that touched on these issues, and I can see lots of different ways to integrate them. But I know we won't have time today. But for those of you who are more expert in these areas than I am, I'm totally fascinated, and I'd love to get more input. So I'll just leave it at that. Thanks to all the presenters, and thanks for having me.
Thank you, Professor Bronin. There's a question about your presentation and also Professor Robertson's. And the question that was posed to me was whether or not there's a risk that these concepts of rights of nature or historic preservation could be abused by NIMBY opponents of a project, the not in my backyard folks who want to say, no, this project can't go forward. There's a right of nature at stake, or there's a historic preservation at stake. What do you think of that comment?
Am I muted or am I okay?
You're okay. I hear you.
Okay. I guess I would say, why should that environmental law be different from any other, right? I mean, most of our laws are used in a NIMBY way. NEPA is, Endangered Species Act is. And if we want to complain about the way a law is used, the law should be written in a way that it can't be used that way. But in general, we use laws as a tool in any way we can.
Yeah, and for historic preservation, I'm just going to drop a note in the chat. I mean, this is really about the creation of housing and abundant, diverse housing, right? And as a preservationist, preservationists have long been tagged as people who are NIMBY, people who are object to new projects. And I'm going to point to in the chat to an effort in Connecticut, where we have gotten the historic preservationists on board to some pretty progressive reforms on housing that we hope to get through the legislative session, which just started today, and environmental groups. So we're trying to concentrate housing in areas where historic places are, historic main streets and clustered development, but also to be smart about the fact that we've sprawled out so far into oblivion that it's really not the right way to develop our actually environmentally rich resource state. So I do think there's a way to harmonize those goals, and I think new preservationists are seeing the opportunity to partner with pro-housing organizations to create abundant housing supply that will actually help us better preserve the historic resources that we have.
Thank you for those thoughtful answers. And seeing no more questions, I'm going to move on to one final set of closing thoughts here. I'm sharing the screen here. Did that make it on the screen? Okay. So what I'd like people to think about is one last concept of state and local government law, and then I'll kind of give a big picture overview of what we've covered in this program. But I spent a good portion of my career prior to joining the Academy in local government, and worked with the South Florida Water Management District, a major regional agency, 16 counties in South Florida, responsible for flood control and water resource protection. And it's funded by ad valorem taxes and annual appropriations through the legislative process. Now, it's a pretty major agency, and in Florida, water management's a big deal at our state and local level. In fact, I did a review in my article in Vermont on all the laws passed from 1997 to 2018, and almost annually, it's a major legislative issue. And you see the same themes popping up over and over. Oversight and comprehensive planning are important. The adoption of new regulatory programs, and most recently, things like reclaimed water or water quality compliance and non-point source pollution. How do we achieve a more sustainable water resource environment? And well, one of the ways is we look at regulatory options. And a third thing that came up over and over again in these laws over time were public works projects, with projects in the Everglades or Lake Okeechobee or the Caloosahatchee or St. Lucie rivers. So time and time again, you see the legislature making a commitment at the state level that we're going to engage in environmental sustainability. We're going to engage in water resource protection. Well, in 2009, the Water Management District wrote a big paper, and their task force pointed out that there are all these climate change risks that are coming. And they identified the quartet of risk in South Florida: rising seas, heat and evapotranspiration, and how that would diminish the water supplies from our reservoirs, floods and droughts because of the changes in the rainfall patterns, and finally, of course, tropical storms and hurricanes. Well, despite this state commitment to water resource protection, despite the recognition of the climate change risks, the Inspector General did a paper in 2018, identified major problems with deteriorating infrastructure in South Florida. And in a follow-up analysis, the Inspector General pointed out that almost half the projects hadn't had any action on them, and that there was need for $88 million to be funded annually for infrastructure upgrades with water control structures, major structures throughout South Florida starting to decay. Well, unfortunately, the budget doesn't really allow for that. And one of the things I did was, in my scholarship, I dug into the agency budget and I looked at what happened. And you can see the dotted line representing what happened to the population growth in Florida. Today, it's almost 50% more than it was in 1995. And yet we saw our budget starting to climb with recognition of our water resource issues. And then we hit an economic downturn, and then we hit some tax decreases. And suddenly we're flatlined for the water management districts in Florida, where today The agencies are being funded in terms of their ad valorem tax revenues at a level about akin to 1996. And that's not much different, even if you take into account the legislative appropriations that are put on top. There's been a dramatic decline in the state and local commitment to water resource protection. That decline also goes to the reserves. There used to be $80 million of reserve funding that was set aside for emergency events. There's very little in those reserve funds now. The number of employees, despite the population increasing, despite all those laws getting passed, the number of employees today is significantly less than the number of employees at that agency in 1995. And as you might imagine, of course, environmental enforcement declined as well. The number of notices of violations being issued by the governors, of course, fluctuates from time to time through the agencies, but you can see dramatic decline in enforcement. One of the key points I made in this article is the disaster is coming. And if you look at the history of FEMA funding and what's happening with our appropriations at a federal level, you see a dramatic change in how much money it's costing us for disasters. From 1964 to the present day, you see the dramatic increase both in the annual appropriations and then in the supplemental appropriations that become necessary when those disasters actually do come. And there's one coming to Florida, and one of my concerns is we're not ready. The state and local government is not funded enough. It's not staffed enough. It is not ready for that disaster when it comes. There are some folks in South Florida who like to use this line, and it's attributed to various people, but they say the Everglades is a test. And if we pass, we may keep the planet. Well, today was a lesson too. And I've got a test question for everybody. Explain whether we should do these things. Should we engage local governments in aquaculture regulation and ocean conservation? Should we engage in the use of financial crimes and local laws for wildlife protection? Should we use the management of groundwater with collaborative governance? Should we embrace the benefits of condos and urban density? Should we empower state agencies to exceed the federally mandated minimums? We covered all those topics in that first half of this program. And then in the second half, we looked at whether or not we can overcome certain obstacles. So the second part of the lesson is, can we overcome the uncertainties of the public interest test? Can we overcome insufficient federal leadership with a model code? Can we overcome the non-delegation doctrine and the instinct to deregulate? Can we overcome the barriers to standing? And can we overcome the destruction of history and heritage when we rebuild? And finally, can we overcome the lack of funding and the lack of staffing to do the job? These are big questions. These are big ideas. I'd say that the model answer is yes, we must act. And yes, we must overcome. I'd say that state and local governments perform a critical role in our quest for sustainability. In fact, it's a necessary role. They, by necessity, have to be part of the federalism dialogue. They have to be part of encouraging citizen contributions to collaborative governance. But perhaps another way of characterizing this is to say that environmental sustainability is a test too. And if we pass, we get to keep the planet. I'd like to thank everybody for joining our session today. I hope you found it informative. I'm thrilled with our panels and how things went. Thank you to the AALS team for keeping the information technology functioning. Blips are going to happen. We appreciate that. And for those of you who are interested, we'd like to continue this dialogue on the 9th floor of the Remo rooms using the coffee break links on the AALS homepage. Thanks for joining us today. Everybody have a great day. Stay safe.
9th floor of the Remo. Okay.
Thank you.
Thanks, everyone. Excellent. We really appreciate you.